This courtroom moment is absolutely wild. What starts as a routine hearing quickly turns into a tense legal showdown when a woman claiming to be a sovereign citizen tries to challenge the authority of the entire court. From the very first seconds, Angela Christensen refuses to even be called a defendant. Instead, she insists she's simply a woman and that the court has no power over her. But the judge? Calm, patient, and clearly not new to this kind of argument. Things escalate fast. She begins warning everyone in the courtroom that she'll file claims and ruin people's lives and jobs if her so-called rights aren't recognized. You can feel the tension building as she talks like she's the one in charge, while technically standing there facing charges herself. The judge then methodically shuts it down. One by one, he rejects her written notices, explaining they have no legal or factual basis. When she claims the government only exists by her consent, the judge flat out calls the idea nonsense and explains the court's established jurisdiction in plain terms. No yelling. No losing control. Just facts and law. But it doesn't stop there. Because of her refusal to follow procedure and her clear misunderstanding of the legal system, the judge actually takes away her ability to represent herself and appoints a public defender. That's a huge moment. The court stepping in because things have gone completely off the rails. And just when you think it can't get crazier, the video reveals she tried to send the court an $86,000 invoice for her travel. Yes, seriously. This is what happens when internet legal theories collide with real courtroom reality, and a judge who isn't playing along.
Good morning. We are back on the record in the 53rd Circuit Court for the County of Presque Isle. And Ms. Christensen, although you're appearing from your home, for convenience sake, it might not feel like a court hearing, but it is a court hearing, so I'm going to ask you to please remove your hat.
Oh, sorry.
No worries. Okay, thank you. All right, so as we begin the hearing, just like last time, I'm required each time to remind you that you do have the right to the assistance of a lawyer if you wish. And that includes the right to a lawyer at public expense if you were indigent, and that you've previously waived that right and wish to represent yourself. And so I guess I want to ask you again, do you reaffirm that you'd like to represent yourself in this matter, or would you like to have a lawyer?
No, I would like to self-govern, and I stand on my paperwork.
Okay, so what we have today, you did file 4 written notices that asked for some type of relief, and we had adjourned the hearing to today for any argument on that. So the prosecutor has had a chance to review them. So Ms. Christensen, you say that you stand by the paperwork, and that's fine. I do have the paperwork in front of me. Is there any argument that you'd want to make on your behalf right now to me in support of those claims, or do you wish to just rely on the written pleadings you filed?
It is my wish to stand on my paperwork.
Okay. Mr. Radsbaum, do the people have any argument in opposition to those 4 notices?
Your Honor, I've reviewed the paperwork, and I guess while she may not recognize or honor the state of the law, I don't believe that there's any relief that's recognized under law that would allow you to dismiss this case against her based on what she's alleged in the paperwork. I fail to see it.
Okay. All right. Well, Ms. Christensen, now I'm going to make a ruling on the notices, which I'm construing as some motion or request for relief. And I've got a written order that I'll enter. I'll read it at this point. Defendant, who at this point in the case is representing herself, has filed 4 handwritten notices. These notices appear to seek relief in one form or another. As to the first notice, defendant asserts that she is a woman and not a defendant. The court finds that Angela Christensen is both a woman and a defendant in this criminal act. To the extent her notice seeks relief, such relief is denied. As to the second notice, defendant demands that any man or woman with a claim against her appear and present such claim in open court. To the extent that this notice seeks to invoke defendant's right to confront her accusers, this court will enforce that right. However, the right of confrontation does not require the complaining witnesses to appear at all pretrial hearings, but only the trial or any necessary evidentiary hearings. So to the extent that this notice seeks to require the appearance of any complaining witnesses at all pretrial hearings, such relief is denied. As to the third notice, defendant asserts that this court lacks authority over her and that only her creator has that authority. Without gainsaying the authority of the creator, it can be noted that religious traditions commonly recognize that the creator has instituted human authority as well. In this matter, the people of the state of Michigan, through ratifying the 1963 state constitution, as well as its predecessor constitutions, have established this court and its authority. The people of the state of Michigan, through their elected representatives, have established laws that apply in this court. And the people of this county have elected this judge to serve in this office. And this court has subject matter over this felony prosecution and has personal jurisdiction over this defendant. Any relief sought by this notice is denied. As to the fourth notice, defendant claims that this court and the government exist only because she allows them to exist. To the extent that this assertion reiterates the proposition that our constitutional republic is founded on the consent of the governed, such proposition is axiomatic as a general matter. However, this proposition does not require that the government must obtain consent or permission from each individual person before exerting governmental authority over that person. Such an idea is nonsense and would result not in a constitutional republic, but in anarchy. This defendant's views would render all the criminal laws null and void, which is legally and practically absurd. Therefore, any relief sought by this notice is also denied. All right, so Ms. Christensen, all of the claims and papers that you have filed, I have found to be lacking in legal and factual merit, and I have denied any such relief. And I'm entering a
That's
order
fine. Can you please stop referring to me as a defendant? And I guess the next step will be, I guess I got to do the actual filing of the claims if you're going to deny all of those.
No, those, I don't know what claims you're talking about. You filed some claims or notices or requests.
No, I did not even file my claims yet. I did notices. I did not file my claims yet. I've been putting that off because I really don't want to have to file claims and ruin people's lives and ruin their jobs because they're not upholding my constitutional rights as a woman, not a defendant. I am a woman only. I, woman Angela. I, woman Angela. I, woman Angela. That's it. Not defendant. I'm not a defendant.
And,
Okay, in your opinion and legalese, yes, but I am a woman. So do we need to do trial by jury when we can do my claims and file my court with your court at the same time? Because that's going to be my next step, to file claims against everybody involved in this case. Because there is no verified claim, and complaints and claims are two different things. I don't want to file claims. I'm trying very hard, and I've been trying hard to not do that. But I guess if we got to keep going, that's my next step. And I will file proper claims with the proper people and the insurancing for the bonding. So I don't know what you want to do at this point. And I really don't want to have to do that.
Ms. Christian, I got to tell you, I don't know what in the heck you're talking about. You're talking nonsense. So here's the thing. I am not going to relinquish my authority in this case. I'm not. All right. The prosecutor's office can dismiss the case. They're choosing not to. So that means we do have to go forward to a jury trial unless you want to plead guilty. All right. But what I'm also going to do is your ramblings here today and at previous hearings, and after I reviewed your written notices, it's clear to me that you have no concept of the legal and factual issues at stake. And
I would never know anything about legalese because I never went to school to do the legalese. So I don't understand that part.
All right, you're illustrating my next point, and you have no respect for the authority of the court. You continue to interrupt me and such, and file these nonsense claims. So I am hereby withdrawing my consent for you to represent yourself, I'm referring this matter to the Office of Assigned Counsel for appointment. So any papers you file in this case, I will reject because they have to be filed.
Well, I don't accept that offer, and I do not require you to give me any court-appointed attorney, and I will self-govern because that is my right. I don't want an attorney. I don't do legalese. I'm sorry. I'm not trying to be rude or disrespectful. I'm trying to be very decent.
Well,
I stand on my paperwork and I'll do the rest of my paperwork. I will keep doing it, and now I'm going to file my claims, so that's fine. But no, I don't need no legal counsel. I refuse that offer. I do not accept that offer. I'm sorry. With all due respect to you, I don't accept that.
well, Ms. Christensen, it wasn't an offer. So we are scheduling this next for a docket call on February 14th.
This courtroom hearing starts like many others, but within seconds it's clear this is not going to be ordinary. A woman standing before the judge immediately signals that she does not recognize the role the court says she has. Instead of answering in a normal way, she challenges the very language being used, rejecting the title of defendant, and insisting she is simply a woman named Angela. That might sound small, but in a courtroom, words matter, and this is the first sign that this hearing is about to go off track. The judge, calm and measured, attempts to move forward with standard procedure. He explains why she is there and what the court needs to address. But instead of engaging with the legal issues, she pivots into a stream of arguments rooted in sovereign citizen ideology, the belief that government authority only exists through personal consent. She speaks confidently, as though she has uncovered a hidden legal truth the court is ignoring. The judge listens, but his expression makes it clear he has heard this before. Very quickly, the tone becomes tense. She warns the courtroom that people's lives and jobs could be at risk if her rights are not recognized the way she defines them. She talks about filing claims and holding individuals personally liable. It's the kind of language meant to intimidate, suggesting that everyone involved, from the judge to court staff, could face consequences outside this room. But the judge doesn't react emotionally. He stays focused on the law, not the threats. At one point, the judge addresses several written notices she had previously filed. She seems to believe these documents carry powerful legal force, as if they can override the court's authority. One by one, the judge denies them, explaining they lack both legal basis and factual support. His tone is not mocking, just firm. In the legal system, paperwork alone does not create reality, and he makes that clear. She circles back again and again to the idea that she is not a defendant. To her, that word implies submission to a system she does not accept. The judge responds plainly, regardless of what she calls herself, she is the person charged in this case, and that makes her the defendant in legal terms. It's a moment that highlights the gap between personal belief and legal definition. In her world, labels are optional. In the courtroom, they are part of structured process. As the discussion continues, she argues that anyone accusing her should be present at every pre-trial hearing. The judge explains that is not how procedure works. Pre-trial hearings often involve legal arguments, scheduling, and motions, not full testimony. Her demand is denied, but again she treats the denial as if it's proof of wrongdoing rather than standard practice. Then comes one of the central claims of sovereign citizen thinking, that the court has no authority over her. She suggests the government only operates through her consent, implying she has withdrawn it. The judge addresses this directly, explaining that courts derive jurisdiction from law, not individual approval. He even calls the idea that government exists solely by personal consent nonsense, not as an insult, but as a legal conclusion. Authority in the system does not switch on and off depending on personal declarations. Throughout all this, the judge remains remarkably composed. There's no shouting, no sarcasm, just steady correction and explanation. That contrast is striking. On one side, emotional conviction and threats. On the other, institutional process and legal structure. The situation takes a significant turn when the judge evaluates her ability to represent herself. In the legal system, representing yourself is allowed, but only if you can follow procedure and understand the nature of the proceedings. Her repeated refusal to acknowledge the court's authority and her focus on arguments with no legal grounding signal to the judge that she does not meet that standard. He makes the decision to withdraw her self-representation and appoint a public defender. That's a major moment. It's not about punishing her for her beliefs. It's about ensuring the case proceeds fairly and within legal boundaries. The judge is effectively saying that without counsel, the process cannot function properly. Even then, she resists, treating the appointment as another violation rather than a safeguard. The judge also orders her to appear in person at the next hearing. There's a clear warning: failure to appear could lead to a warrant for her arrest. It's a reminder that, regardless of philosophical objections, court orders carry real consequences. Then the video reveals something that almost sounds unbelievable. She attempted to send the court an $86,000 invoice for her travel to a previous appearance. To her, this may feel like asserting a contractual right. In the legal system, it has no effect. But it perfectly illustrates the gap between her understanding of law and how courts actually operate. As the hearing closes, what stands out most is not just the clash of ideas, but the difference in approach. She relies on declarations, personal definitions, and threats of paperwork. The judge relies on statutes, precedent, and procedure. It's a collision between internet legal mythology and the structured reality of a courtroom. For viewer, it's a fascinating, tense look at what happens when someone walks into court believing the rules don't apply to them, and meets a judge who calmly demonstrates that they do.